Is it completely wrapped now? Is this the end of it? Or what's kind of like the aftermath or the forward-facing, view of this case?
So whenever you have a child custody case, like family law cases are very unique in the respect that orders can always change based on changed circumstances, right? Regarding the child. So family law orders are supposed to be fluid, right? They're supposed to be adaptable, right? So getting to your question about whether this is the end or like it's all wrapped up, yes and no.
Welcome to Just Settled. On today's episode, we have with us an incredible guest out of Sacramento, California, Matt Tabo of Tabo Law, family and criminal defense attorney, does incredible work up there. Matt, thank you so much today for joining us on Just Settled.
Thank you for having me. It's a pleasure.
And I'm Dan Taft, the host of Just Settled, the marketing director of LegalSoft. We were talking about an interesting case right before we came on camera, and I kind of wanted to dive into all the details about it, have you tell the audience this one just settled today. So it's really, really recent, literally fresh case that just happened, child custody and support case. Matt, I'll let you intro it and overview everything. How did you first learn about this case? And can you kind of tell us some of your initial thoughts when it first came across your desk?
Yeah. So the client first came to me and hired me, I think it was about maybe 2020 or 2021. So, we've been litigating this case for about 3 years. And I kind of came in, kind of in the middle of this case. So the very quick background is my client is the father of an 8-year-old child. There's a mother that has a domestic violence restraining order against him.
Mm-hmm.
Domestic violence restraining order is a big issue. There was a finding of domestic abuse against him. All of this occurred before I came into the case. And so initially, when he came to hire me, he wanted to just see if we could do something about getting the restraining order terminated. And that was it.
Right.
Well, it went from that to about 7, 8 different types of matters. It just morphed into this incredible litigation monster. And a lot of it had to do with just the obstinate nature of the mother and her attorney, and they were just fighting everything. My client wasn't certainly blameless in terms of like the amount of litigation, but it just, at one point at the end of 2023, there were 7 or 8 different matters, about 3 or 4 different trials, all set around the same time. So it just became this just incredibly overly litigated monster. And then we had trial after trial. And then eventually, we were able to stack up enough wins to the point where we got to this morning, which is we had a mandatory settlement conference on 2 upcoming trials, and we resolved those 2 trials. And now there's nothing on the calendar for him. And he's gotten a significant increase of his custody time. We've beat the domestic violence restraining order in trial. We won a motion for contempt against the mother, showing that she had violated the orders on several different occasions. And then we'd also had gotten a very favorable ruling on child support. So there was just, I think at one point, 5 or 6 different trials.
Wow.
7 or 8 different matters, hundreds of thousands of dollars, attorney's fees just expended. This case was pretty insane in the amount of litigiousness.
And I'm sure there's always anytime a new case comes in, right, there's uncertainties or just sort of hurdles that you're going to have to get past or challenges. What were some of those first I don't want to say concerns, but just like uncertainties or things that you knew were going to be specifically tricky about this case and how it might play out when you kind of started navigating it?
Yeah, I mean, there were a lot. And one of the things, I think one of the big lessons from this case specifically, and this is something I had told my client repeatedly, tell a lot of my clients, which is sometimes when you're having all of this litigation, right?
Yeah.
Things aren't seemingly the way that you want them. They're not going seemingly the way you want them to go. You have to keep your eyes on the long view. You have to keep your eyes on the macro level view of your case, which is to say, be patient, stick, right? Stack up the wins, and then eventually you'll get to where you need to go, right? Hopefully, right? If we do this the right way. And so one of the initial challenges, getting back to your question, is he had this domestic violence restraining order against him, right? And so there's an interplay between having a domestic violence restraining order and having child custody of your kid. And so if you have finding of domestic abuse against you, you're presumed to essentially be dangerous to the child, right?
Right.
So I'm just very generally paraphrasing the statute, but there's a presumption called the Family Court 3044 presumption in California, and that's basically what it says. It's if you have a finding of abuse, then the court is going to deem you as like you should not have a joint legal or joint physical custody of your child, right? And you could do other things that kind of rebut that presumption. So he had this presumption against him. And so from the beginning of my involvement in this case, he's kind of starting from the bottom and he has to claw his way back up to the top or claw his way back up and increase his time over and over again. And the biggest kind of source of tension between these two parties is obviously their child, right?
Yeah.
And so that was a huge issue because anytime we came into court, anything that we filed, she was throwing that in his face over and over and over again. And rightfully so, right? I mean, that's what I would have done on the other side. So he had this tremendous hurdle of having to essentially repaint himself as someone who's safe, someone who is a good father, someone who's doing everything that he can. But that's tough, right? And you have to continually build that over time.
Right. And when you were first kind of speaking with your client in this case, what were, I guess, some in terms of, not restitution, but in terms of outcome, were you aiming for joint custody? What was sort of the goal when you were kind of coming into this? When you speak of long view or the bigger picture, the macro, what was that in terms of what the client was seeking?
Yeah, so he wanted custody or at least joint custody of his child, right? So that was kind of like the longer term view. Obviously, in the beginning, he also thought that he should be the primary custodial parents for a number of reasons. And I had to explain to him, like, you're not going to be able to accomplish that on the first go, right? You're going to have to build your way up there. So in the short view, he wanted to just increase his custody time and also get back his legal custody because that was something that was taken away from him when he got the restraining order granted against him. So those are kind of like the short view things. But in the longer view, he wanted to be an equal parent or at least, have like a significant say in what's going on in his child's life. I mean, this is a kid that when we started this litigation was about 6 and now is, about to turn 9. So this kid has, his entire life ahead of him. These co-parents have a long time that
Right.
have to be able to co-parent, peacefully, hopefully, for the best interest of this kid. So the short term was just trying to increase here, like little by little by little. The long term was just like, he's like, I want to be a 50-50 parent, right?
Yeah.
Along the way, all of these things were happening where she was mother was violating the orders. We had to file motions regarding that. She had filed several motions for attorney's fees against him. She filed a motion for child support claiming that he was earning like $500,000-$600,000 a year when there was no evidence of that. And we had to take that to a trial. And then she filed a motion to renew the restraining order. So we had to fight that. Then she filed a motion against him. And so it was just all of this back and forth. And a lot of it was unnecessary. In my opinion, a lot of it shouldn't have happened. I think the attorney on the other side, trying to be kind here, I don't want to, disparage anyone specifically, but I think the attorney on the other side, in my opinion, should have done a better job of kind of controlling her client.
Yeah.
Saying, hey, like, this is only going to make things worse for the both of you if you file this, right? There's really no basis for this. And there's other ways for us to kind of resolve this without filing another motion. But that didn't happen. And so, we just had to slowly chip away out of it to the point where we got to right now, which is 3 years in the making, where he has gotten, he's in a really, really good spot now.
It's incredible, right? That journey from the beginning to the end. I can imagine, a lot of probably twists and turns or things that may have been kind of curveballs coming at you guys while you were doing that. We talked a little bit about, some of what, might fall into like typical opposition or obstacles or hurdles that you had to overcome in this case. Was there anything that was kind of unique or just something maybe that you hadn't seen before that felt like you were like, oh, this is something new that I'm coming up against in this case, or just something that maybe you didn't anticipate in the beginning that when you got a little further in, you kind of were like, oh, this is how this is going to play out and how I have to kind of adjust, any mid sort of case adjustments and things like that?
Yeah, there were. And part of it I've kind of already like hinted at. And I think the big thing that really surprised me about this case was really kind of the conduct of the opposing counsel. And the fact that the opposing counsel, look, I'm not sitting in on her meetings with her client, right? But the fact that she filed these motions, like motion after motion, that either were procedurally defective, didn't have the evidence to back it up, didn't have any real strong legal arguments. And I think she was just kind of kowtowing to what her client wanted instead of like exercising like a real measure of like discretion and client control. That really surprised me. And a lot of times, I like to give attorneys the benefit of the doubt, right? I like to think that, great, we have an attorney in this case, right? Rather than dealing with a pro per, right? You assume, me being an attorney, I assume that this case is going to be easier to deal with now that I have an attorney, right? That someone who knows the law, who knows the legal standards, who knows what we should be doing, and who also should be focused on, the best interests of this child, right? And this family. And that's not what happened. And every time we would get a motion, I would read it and I would just be flabbergasted because I would just say to myself, I can't believe this attorney is making this argument. And, I learned pretty early on to not give other attorneys more credit than they're due, right? Sometimes like you get something, you're like, there's no way they're making this argument, right? They have no chance of winning. Like why would you do this, right? They must have some kind of ace up their sleeve, right? And what I've learned in my practice, in my experience, is a lot of times they don't. They're just filing this kind of frivolously, right? And so that much was actually borne out in this case. Like the opposing counsel had filed several emergency motions. All of them got denied. All of them were properly denied. She had filed several discovery motions against us, claiming that we weren't producing discovery or producing certain types of discovery, that we were trying to hide things. Those motions were procedurally defective, that she didn't meet and confer with us. There were just a whole host of issues, not to mention that what she was saying was false. And those motions were denied. So just the level of acrimony that was essentially abetted by this attorney, right? I don't want to ascribe to her like nefarious motives, but
Sure,
she did not help the litigation in this case like I thought she would. And I thought that was really unfortunate. And that at the very end, her client ended up being pro per because she couldn't afford her attorney anymore. And then, the motion that we just settled this morning, she was literally crying to our settlement conference judges saying like, I'm over $100,000 in debt to my attorney. And I had to say like, you did this to yourself.
yeah.
And it sucks, right? Because you kind of feel for the human, but at the same time, it's like, you got to learn that like, if you're just going to be filing all these things frivolously, like at one point it's going to come back and bite you in the butt. And I think that's what happened for her.
Yeah, and it is interesting because you would think that attorney would step in and kind of, and maybe she did advise her about that, Dick. Who, like you said, you're not in the room, but it is an interesting, something I have not heard, much before, honestly. And now it's, it is a unique thing to this case. In terms of timeline, you said this first came in 2020, right? So can you kind of just outline, and obviously you said, I think it closed today, literally, right? So was that a 4-year timeline or total? What did that look like from start to finish, just in terms of, just length? And then, is it completely wrapped now? Is this the end of it? Or what's kind of like the aftermath or the forward facing, view of this case?
So whenever you have a child custody case, like family law cases are very unique in the respect that orders can always change based on changed circumstances, right, regarding the child. So family law orders are supposed to be fluid, right? They're supposed to be adaptable, right? So getting to your question about whether this is the end or like it's all wrapped up, yes and no. Like yes, in the sense that there are no court hearings or trials still left on the calendar.
Mm-hmm.
But no, in the sense that anybody could still file something at any point in time of this kid's life while he's still a minor, of course. And so you just never know what's going to happen. And with these two parties who have just shown such an inability, at least so far, inability to peacefully co-parent and just work with one another, I would not be surprised one bit if I get a call in about a couple months saying, Matt, she filed something new, or like I want to file this motion or something like that. So yeah, I mean, there's still more that can happen. But as for where we were even just a year ago with like 7 open matters, 4 different trials on calendar, all of that's gone. All of that's seemingly resolved for the moment. And I thought we reached a very good resolution today. So it's definitely been a long time coming. I did not expect this amount of litigation. I mean, my client just personally has spent over, I think it was about $150,000 that he spent on this case.
Wow.
My firm alone, and for a family law case, that's just insane.
Yeah.
One of the pro tem judges that we were meeting with today for the settlement conference that we had today remarked that the court file is 7 volumes long. And she was just like, this is too much.
Yeah.
Just like, this shouldn't be like this. And it's clearly a sign of a case that's been overly litigated. And I 100% agree. This case should not have been litigated this much.
Yeah.
I mean, there were a lot of factors at play. I think, my client was a little difficult for sure. I mean, he's not blameless, but I think the mother in this case, I'm not a psychologist or therapist or anything like that. I'm not qualified to diagnose anybody, but kind of classic forms of narcissism where you always think that something else is somebody else's fault, never take responsibility for anything. And even when the court would make rulings like, we got this contempt motion where we won, where she was found guilty of 6 different counts of a contempt of court for her violation of the child custody orders. And even after that, she couldn't wrap her mind around that she did something wrong.
Yeah.
And so it's difficult all the way around.
Yeah, that is a bunch of challenges that I would imagine made this, take the time that it did and also just kind of compound on top of each other, right?
Yep. On a daily basis, I manage enough clients to sue the entire populations of Manhattan, Long Island, and Queens. My firm's got 10 to 15 virtual assistants working every day. Paralegals to do all the stuff I hate. Intake specialists to increase my revenue. Remote attorneys to help my clients. Document retrieval when they're not local. And it's all virtual. How? Because LegalSoft's awesome.
Was there a point in this case when you were working on this that you knew that, or were hoping, or kind of had a sense that it might settle or come to some sort of resolution? Obviously, again, like we said, this literally just happened today that you came to this resolution. When did you kind of see that you were getting closer to that, or you were like, oh, this is possible that we could actually come to terms here?
We settled this case at 12:25 p.m. today.
Yeah.
I first got that sense maybe 11:45.
Wow.
Yeah.
Yeah.
I thought we have a trial set. We had a couple of trials set. And so I was fully expecting to go to trial. I was fully expecting to continue to have to litigate this case. And again, I think that's kind of one of the lessons that, I kind of take from this case, which is I had to do a child support trial in this case. I had to do a contempt trial. I had to do a trial on whether or not his restraining order would get renewed. And we were very successful in all of those phases. And I think for her, just having to take, like in Gen Z parlance, just L after L after L on these different matters, I think it finally just, finally sunk in for her that like she's not going to have a strong chance of prevailing. And that's what the settlement conference judges were really, pressuring her on. It's like, look at your history in this case and all these motions that you filed that have failed. Really think you're going to do well at these other 2 trials, especially since she's pro per now and seemingly can't afford another legal counsel.
Yeah.
So she's already at a disadvantage. But yeah, I mean, that was one of the things where, when I looked at it, just having to do this over and over and over again with this person, like I don't want to say I'm cynical, but I'm always hopeful. But in a case like this, I always just had this thing like, no, we're not going to reach a resolution.
Yeah.
But it's not for lack of trying.
Sure.
The thing, so in March, we had a trial on our motion for contempt against her for violation of the child custody orders. And then the next day we had a trial set for her motion to renew the domestic violence restraining order. And in addition to that, we had these motions for attorney's fees and sanctions, and she had a motion for contempt against him. And so back in March, I sent a settlement offer letter and I was like, look, we'll drop our motion for contempt. You drop your motion for contempt. We'll drop our motion for attorney's fees. You drop that. And then for the domestic violence restraining order, like we'll agree to like a civil no contact order, right? Which is technically not a restraining order, but it still gives her a little bit measure of protection.
Yeah.
And she didn't want to do it.
Hmm.
And then we went to trial and we won the contempt, and we went to trial and we beat her DVRO. So she came out way worse after that. And then we filed another motion for custody, and my guy pretty much got his 50-50, and he got his legal custody back. And then, so it's just all these things that, we were trying along the way to say, like, we don't have to do all these things. We're trying to resolve it. And, the other side, for whatever reason, again, I'm not a psychologist or therapist, but it definitely sounded like someone who just had a complete inability to take any kind of responsibility.
Yeah.
And an attorney who just was not helping that. And even this morning, we were trying to resolve it, saying like, I'll drop our motion, you drop your motion. We just walk away and, you guys start clean. And initially she didn't want to do it. And she was making all these outrageous demands. And I didn't even want to deal with it. I was like, look, if you're not even going to try to be in the ballpark of just just a reasonable resolution, then I'll see you in trial. And I really was just very firm with her. And then finally, it took a lot of pressure from the settlement conference judges saying, what are you doing? You're going to lose,
Yeah.
Your family has gone through enough. This
Right.
kid. And that's what it took. I think it took for her to hear from two other judges to say, like, you need to drop this now. And she finally did it.
Yeah. And that kind of dovetails into what I was going to ask next, which was about negotiations and how that kind of process unfolded. Obviously, the other side is always going to advocate hard, usually for their interests. What were some of the strategies that you used when you were kind of, you said to drop the motion, we'll drop our motion, kind of those kinds of things. When you were advocating for your client's interests, was that sort of your primary strategy, or what was kind of your approach just strategically in the negotiations?
Yeah, I mean, it's a good question, right? And one of the strategies that we used was filing this motion for attorney's fees, asking the court to have her pay us over $150,000 in fees and sanctions for all of these failed motions that she had brought. And I think legally, we were definitely legally sound on our arguments. So for example, she had filed 2 different discovery motions against us. And in California, the discovery statute says that the prevailing party on a discovery motion is entitled, shall be paid, attorney's fees and sanctions, right? And it's supposed to, that statute is supposed to dissuade people from bringing, discovery motions, right? The court wants you to resolve these things informally. Well, we won. We were the prevailing party on 2 different discovery motions. And so, we were definitely entitled to fees from that, as well as a whole host of other issues that mother had done to drive up the cost of litigation. But, and here's the kind of kicker, and this is where, I'm sure you probably get into some of this with your other civil litigation attorneys and civil litigation people that you've interviewed.
Yeah.
Because you have a good legal argument and you're likely to win on that claim, doesn't mean you're going to get paid.
Yep.
And this whole concept of a judgment-proof party, right? Where it's I can get a judgment for $1 million against you, but if you have no reasonable way of ever paying that, then what's the use? Right. And so she's kind of on the lower earning scale, I would say. She's definitely kind of lower middle class. She didn't have a ton of assets, neither did my guy. And so we filed this motion knowing that legally, I think we're pretty sound, but she's never going to pay this, right? Yeah. And that could be one of the things that the court says, right? Because, for example, for a discovery motion that you beat, the statute that talks about the prevailing party is entitled shall be paid attorney's fees and sanctions, unless the other side has an inability to pay, right? And so that was always the big thing that I had talked to my client about, which is look, I think you want to file this motion, right? And I think you want to file it to put more pressure on her. So really, it's kind of a leverage ploy, right? But you need to know that we're probably never going to get paid on this. And even what we would have to expend to have to file this is going to rack up at least another tens of thousands of dollars, right? But we're not gonna get paid on that. But you're doing it as a leverage ploy, right? You're saying look, here's another thing that I'm going to get against you. And here's another thing that gives you another chip that you could play at the negotiating table. Right. And it worked. In my opinion, it fully worked, because that was one of the things that, we went to a settlement conference today specifically for attorney's fees and sanctions. And that's when the judges were like, you're going to lose, And so we got her to drop her contempt against my client and her cross motion. And then we dropped our motion for attorney's fees against her. And then that's the way we resolved it. Right. So that was one of the things where like the case just became so incredibly litigated that, we were like, look, what's one more thing that you could just add to the table? Like, fine, if we could do that to put some extra pressure on her. That's one of the things that worked. The other things that didn't work in terms of negotiations were like, because she was just being so unreasonable. We tried to say like, hey, we would give you this, we would take this, right?
Right.
And none of that stuff worked. So what really had to work in this case was we just had to litigate it, and we just had to win. We won every step of the way, and I think that, in addition to putting the extra pressure on her with these other emotions, is really kind of like what brought us through the finish line at the end.
Yeah, and speaking of that, what was the final outcome today, and how do you sort of, again, future facing, see this positively impacting your client? You mentioned obviously this felt like I'm sure a big win today after all the kind of trials and tribulations of the whole process. Can you just kind of speak to what the actual terms of that were that were kind of agreed to upon today, and again, how sort of your client's reaction to that outcome?
I mean, the terms were very simple, right? So we had cross motions for attorney's fees and sanctions against each other, right? And in family law, there's a couple ways to get attorney's fees from the other side. One is what's called need-based. So you have to prove that the other side has, there's a disparity of income. So basically, that the other side has a higher income or significantly higher income than you, so that in order to level the playing field, you need to get some attorney's fees, right? And the other really big way is through what's called California Family Code Section 271, what we commonly refer to in the family law field as 271 sanctions. And that's basically this kind of catch-all statute that basically says, if you're over litigating the case and you're frustrating the policy of settlement, which family law settlements are always the goal, right? Because obviously divorces, kids, settlements are always going to be better in all of those situations. If you're frustrating the policy of settlement, then the court can sanction you and make you pay attorney's fees and sanctions to the other side, right, under the statute 271. So we filed a motion where we were asking for over $150,000 in attorney's fees and sanctions. They had filed one against us where they were asking for like a little bit north of $100,000. And then there was this other outstanding motion that she had filed claiming that my client had violated the custody orders on several different occasions. And so that was also set for trial. So the resolution today was just everybody drops everything and we just walk away.
Oh, okay.
Very simple, very clean, and really just kind of gave my guy a lot of vindication.
Yeah, no, that's great. That's great. Well, again, Matt, thank you so much for talking to us through this case today. Here, definitely something that we had not touched on really before, kind of all the details. Again, Matt Tabo, Tabo Law, Sacramento, California, family criminal defense. If you need somebody up there for any of those services, can't recommend anybody better than you, Matt. And thank you for being with us today on Just Settled.
Thank you for having me. It's been a pleasure and it's been an honor. So anytime.
Absolutely. We'll love to have you back.